The Legal Aid Center of Southern Nevada and the William S. Boyd School of Law have partnered for more than 10 years in offering free legal information classes to the public. These classes are in topics such as family law, guardianship, small claims court, bankruptcy, and foreclosure mediation. These classes are taught by law students and supervised by our attorneys.
In our long-standing partnership with Legal Aid Center of Southern Nevada, over 30,000 Clark County, Nevada residents have taken these free legal education courses, learning important information related to their particular legal disputes and to their rights under the law. We continually review and expand these programs and are happy to provide this service to the state of Nevada and its citizens.
This video is part of our effort in making this information on bankruptcy more available to the public.
Well, hello. Thank you for coming today. This is the Legal Aid Center of Southern Nevada's Bankruptcy Community Outreach class. We partner with the law school, and I just wanted to thank you for attending. I hope you find the class informative and useful. And with that, we'll get started. There are 5 critical issues that we hope that you will take from this class. I'm going to go ahead and go over them up front so that you can recognize them when we talk about it later in the presentation. We recommend that you take notes while we're doing the presentation so you can refer back to them later if you decide you need a little bit more information. The first one is an automatic stay. Just be mindful of that as we further talk about it later in the class. The concept of discharge of debt, the concept of exemption and equity, concept of preferences and transfers, and the final one, we're going to discuss bankruptcy alternatives. So the purpose of this class is not for legal advice. It is strictly for legal information. Based on the volume of people that we see, we're not able to talk about your personal factual circumstances, but we do hope that we can at least give you some background information to help you make a decision about which bankruptcy is going to be better and most suited for your needs. We will be talking specifically about Chapter 7 and Chapter 13. Those are consumer bankruptcies, and that will be the limitations for today's discussions. Bankruptcy is complicated. We strongly recommend that you seek attorney counsel for filing your bankruptcy. There's just a lot of ins and outs and a lot of pros and cons to it, and you want to be aware of those and mindful of those when you are pursuing bankruptcy as a relief. Bankruptcy actually started and originated from the Old English debtors' courts. It is federal law. It is not state law. It is federal law. And back in 2005, there was a reform of the bankruptcy law called the Bankruptcy Abuse Prevention and Consumer Protection Act. The purpose of bankruptcy is we try to give individuals a fresh start. Its purpose is to relieve financial pressures that debtors are experiencing, and hopefully we'll give them that fresh start to begin again. We do expect that the debtors act in good faith. The bankruptcy code is very specific about that. You will be discharging all of your debts or adjusting depending on which bankruptcy you're filing. It also does take into consideration fairness to the creditors. So while you're acting in good faith, we hope that it also will be fair to all of your creditors. Your debts will be permanently erased as a result of the bankruptcy filing, and thereby giving you that fresh start. The benefits of filing bankruptcy include, obviously, the discharge of your debts. It will stop collectors from calling you. It gives you an opportunity to work out an IRS repayment plan if necessary. It will stop wage garnishments, and it can temporarily stay a foreclosure. Now, again, I stress temporarily stay. I think there's a general misunderstanding in the public that just because you file bankruptcy, that will actually stop foreclosure. It only temporarily stalls a foreclosure until you take steps to secure the property by resuming payment, if that's what you decide to do, and keeping the house. Debts that are not dischargeable in bankruptcy, we'd like to cover that because there's a misunderstanding also in the public about what bankruptcy will do for you. Bankruptcy will not discharge what we call domestic support obligations. That includes child support, alimony, anything that has to do with family. It does not discharge those debts. It does not discharge IRS debts. There are exceptions to that, but that's beyond the scope of our class today. Bankruptcy will not discharge your student loans. Student loans are intact and will survive a bankruptcy filing. Will not discharge court-ordered restitution, And one of the strongest things we try and stress today is that your debts that are not listed in the bankruptcy, those will not be discharged either. Debts that were incurred under fraud, such as if you put false income on an application when you're applying for credit, those debts will not be discharged. Credit card binges that you've incurred within 90 days of filing bankruptcy, those will not be discharged if a creditor actually identifies that those charges were made 90 days prior to filing the bankruptcy. Yes, do you have a question?
If your property is foreclosed on, can your equity or second mortgage be discharged?
With respect to your first and your second mortgage, whenever you file bankruptcy, your personal liability is discharged. The remedy for the creditor is to go after the property specifically. So the discharge will act as a personal liability discharge. Yes, go ahead.
Are payday loans dischargeable?
Payday loans are dischargeable in bankruptcy. The last thing that is not discharged is ATM cash withdrawals. If those are done within 70 days of filing your bankruptcy, again, it's up to the creditor that they have to bring a dischargeability action against you, indicating that the debt should not be discharged. And that can happen in a bankruptcy, so we do like to make people mindful of that. Now, there are 3 different ways that you can file a bankruptcy. One is through an attorney. One is what we call pro se, that means that you file the bankruptcy yourself. And the final is using a document preparation services. Obviously, we urge you to talk to counsel prior to filing bankruptcy. It is complex, and again, we want you to understand the pros and cons and effects of filing the bankruptcy. And it does affect you for years to come. If you decide to file on your own, again, you're able to do that. We call that pro se representation. Forms are free on the Nevada District Court's website. That's at www.nvb.uscourts.gov. We do put that link in our manual, so you can refer to that later if you so need to, but that is where you can download forms for free. We've all seen in the past the legal form stores where you can buy the documents, but it's not necessary anymore. The final is the document preparation services. It's important that you be aware that these individuals are typically paralegals. They are not attorneys. They are not licensed. And as a result of that, there's no entity that is actually monitoring their conduct. So we highly stress that paralegal preparers probably are not the best way to go. They do not represent you in the courtroom. They do not sign your documents. They do sign the petition initially that they prepared the documents for you. But you are signing your documents under a penalty of perjury that all of the information is correct and accurate, and that is taken seriously by the trustee and by the courts. My biggest concerns about the document preparation services are that, again, they're not going to be there when you're in court or before the trustee. So just be mindful of those 3 ways that you can file, and again, of course, we think that hiring an attorney is the best way to go. Now, there are some myths surrounding filing bankruptcy that we want you to be aware of, and we want to clear up any misconceptions in the community about. The first one is, I do not have to file a bankruptcy against all of my creditors. Well, that is not true. We don't have the luxury of picking and choosing which debts we're going to list in our bankruptcy schedules. Part of the theory about being completely honest and accurate is you have to list every debt. That includes debts that may be owed to an uncle or a cousin or a friend. You want to include and list all of your debts. Number 2, don't have to list all of my property. This again is false. It is criminal to intentionally leave out assets that you own, even if they were given to you as gifts. So you want to make sure you're being comprehensive, including all of your asset items. Number 3, they cannot take my home. Again, this is false. There is a homestead exemption that we're going to talk about a little bit later that does provide some protections, but the bottom line is if you're not making payment to your secured creditor, then they're going to be able to come back and get the property. And that's true for your car as well. If you'll notice, number 4, they cannot take my car. Again, there's limited protections for cars. However, the protections are not speaking to the auto finance company or the IRS.